Hello, everyone. Welcome to another episode of AMP Spot Talk. Here we have John Igarashi here, Law Office of John Igarashi. Talk about some law aspects and to see, what can we do as a person if we have some legal issues. So, John, thank you for coming. Appreciate it.
Thank you, sir. I'm very happy to be here. As you know, I've known you for quite some time, and so when you invited me here, I was very honored to be a guest on your show. So thank you.
We are honored here by your presence, and I've known John for ever since high school.
Wow.
Yeah, so pretty cool cat here. He sings, he dances, he's a DJ,
Well,
break dance,
these
he's a
are-
cross country runner.
these are activities from years past, but yes, presently employment lawyer, as you know, employment and business litigator. So
And tell me, so let's plug you in right now. Where's your office? How long you been in business? And your specialty of law that you practice?
I've been practicing law for, I'm embarrassed to say, 25 years.
Great.
And my office is in Irvine, although I practice all over. I'm licensed in California, and I am licensed to practice in all federal courts and state courts in California. Also, the 9th District Circuit Court of Appeals, which is the federal Circuit Court of Appeals that covers California and other states. And then I am also licensed to practice before the United States Supreme Court, which not all attorneys are.
Interesting.
Wow, so you need special licenses to practice in these courts? Or how?
There's only one bar exam that I had to take, which is the California bar. And for most of the courts, it's just a matter of registration, registering with them so that you're authorized to practice. And sometimes they kind of do a background check to make sure that, you have the qualifications. But the U.S. Supreme Court is somewhat of an honor because you have to be vouched for by other U.S. Supreme Court bar admittees.
Right.
So they vouched for me, and the Supreme Court took a look at my record and said that's fine.
Right.
So anyway,
So I want to probably dabble in some topics.
Okay.
All right. And I understand, you're a lawyer and you have certain views on topics, but number one I want to talk about is the CCW. Is that a
What's a
good subject?
CCW?
in California, that's a concealed weapons permit.
Oh, okay.
So I'm happy to talk about that subject with you. Although no specifics as to any
No specifics.
personage.
I just
Okay.
a lot of people right now, practicing the First Amendment and
Second Amendment.
I'm sorry, second. Thank you. Second Amendment. They want to carry concealed weapons to protect them because of what's happening, COVID, racism, protection from robbers.
Crime is up. They say
crime is up.
in large cities.
Are you ready for the bad news?
Is it true?
Well, no, all of that is true.
Okay.
But the bad news is, in general, those will probably not be grounds that are sufficient to show good cause, which is what's required to obtain a CCW in, I would say, at least Los Angeles. It's a very difficult county to obtain a CCW. And even though we've heard comments from the sheriff recently that he intended to increase the number of CCWs by fourfold, I found out that there were only about 200-300, I think, CCWs issued in the county.
In Los Angeles County.
In Los Angeles County.
Okay.
So even if it were increased by 400%, and I don't know if that figure is accurate, but I figure it's in the ballpark if that's what I read, that would still be only maybe 1,000 permits even after that increase. In Orange County, I think there were around 10,000 issued.
Yeah. My buddy, I won't say your name, but my buddy just got his CCW.
You won't say his name?
I won't say his name, but I'll say his occupation.
What's his occupation?
Mechanic.
Okay. In Los Angeles County.
No.
Orange County. Right.
Right.
Okay. Well, it is harder than it was just a few years ago because there was a case that came out of San Diego where the sheriff, I can't remember the exact facts, but the sheriff had said, if you simply state that you're concerned about your personal safety, that is sufficient to show good cause. And so Sheriff Hutchins at the time, Orange County Sheriff Hutchins at the time said, well, if that is an acceptable standard, we're going to do it too. And so at that time, which was years ago, it was sufficient just to say that you were concerned about your own personal safety, and they were issuing CCWs on that basis. That case, I think, I don't know if it got overturned or if the Ninth Circuit took a look at it, but the standard changed back to good cause, meaning it's not sufficient good cause just to say that you're concerned about your personal safety.
Okay.
So now you have to show, I think once again, they're requiring that people show that there is some reason that they need to carry a concealed weapon. And people often, will come up and say, well, I have cash at my business, or, something like that, or I'm concerned about my safety at my home. But if it's your business, you are entitled to have a weapon there in general.
Right.
And if it's your home, you're almost always entitled to have a weapon there as well. I mean, absent any other factors that prevent you from owning or possessing a firearm. So that is not good cause for people to say things like that, because you're already entitled to have it there. They want to know why you need to have it carrying it on the street. You know what I mean? So people will often say that kind of thing on their application. My understanding is,
right.
And they say, well, you can already have a weapon at your business. You can already have a weapon at your home.
Without a license,
without a CCW,
right,
at least.
Right.
And so they say, what we want to hear is, why do you need to be carrying it around with you? And people often don't answer that question adequately, is my understanding. I don't work for their sheriff's office.
Right.
I kind of try to watch these things. Like there was a case in Hawaii called Young versus Hawaii, where I think that person applied for a CCW, Young, Mr. Young. And that case just got resolved against him by the Ninth Circuit.
Oh, really?
But, basically Hawaii wasn't issuing any. So he said, you're infringing my Second Amendment right
to carry.
And the Ninth Circuit said there is no such right to carry, to bear, to keep and bear in your own home.
To bear arms, Second Amendment.
In your own home.
There is.
There is. But to carry it around outside. And so this is a very dangerous topic to talk about, because people are going to agree and disagree in their own way.
Right.
And some people will say, well, that's not bearing arms. That's just keeping arms.
Right.
But
I see.
The law sees it differently. So.
It's very, very touchy, huh?
Yeah. I don't know if you want to go into this subject in your podcast.
Well, I just don't know. A lot of our listeners are very interested, or approached me and asked me about, hey, you know how to get a CCW? I'm like, not really. I mean, I think you could download an application and fill it out and pay a fee.
Right.
Do you have to hire a lawyer? Do people ask you that?
I have never heard about anybody hiring a lawyer to do that. But
okay.
I mean, I guess there probably are some lawyers who might. I don't know. I haven't researched it. I know that there is a lawyer that was doing a vlog on YouTube, and he was basically addressing Second Amendment issues. But I think he actually went to work for one of the organizations that defend Second Amendment rights.
Oh, okay.
Or I guess that's how they would put it.
Interesting.
Yeah.
So maybe you could contact a Second Amendment right lawyer and probably help us out with the application.
I don't know. I think
maybe.
My recollection is that lawyer's last name was Miranda.
No, Miranda.
Which is funny because,
Miranda
it's like your right to remain silent kind of.
Right.
But
all right. Well, I mean, I know that's not your type of, you don't practice in that type of law.
Not my field at all. No.
Not your field,
but, I do try to, take note of cases that come out. So it's interesting. And actually, there are a few cases before the Supreme Court, I think. That are set to be decided that will have an impact on that area of law.
Right.
So,
tell us a little bit about the law that you're practicing right now.
Oh, thanks, Joe. Well, right now I'm practicing employment and some business litigation, but primarily employment. There is an interesting story behind that, but it's how I got into employment law, because I originally was practicing business litigation. But as you know, I have a theater background.
Right.
And so I was doing a musical theater fundraiser for the Children's Hospital of Orange County called the Chalk Follies.
Okay.
And through that fundraiser, it's basically mostly business people, lawyers, professionals who get together and perform. And then people come and pay to see them, and then it's donations to the Children's Hospital. It's their second. It was at the time their second biggest fundraiser behind Chalk Walk, which I think is a Disney thing. I think they walk around Disney to raise funds. But in that case, so I met an employment lawyer, a fairly famous employment lawyer named Michelle Reinglass, former OCBA president, and so she kind of recruited me over to her law firm. From another law firm that I was working at that time. And so it was, it was interesting. It was a good thing, thing that I enjoyed doing, utilized some of my talents and hopefully made a good contribution to the Children's Hospital and society or whatever. Yeah. But then in addition, it made a good connection for me, I guess. And so, I considered that to be a good experience, and that launched me into my own practice.
So you practiced law for 2 years and then went to employment?
Oh, wow. It must have been probably 6 years at that time.
Okay, so business litigation for the first 6 years.
And then another 4 years.
And then another 4 years.
Ms. Reinglass's office. And then,
which is employment law.
Right. And then I went into my own practice. And
what are the challenges of having your own firm versus working for another attorney or another firm? I mean, any disadvantages or advantages?
Lead generation, I guess. If you work for a firm, generally you're assigned cases by the partners, or if you're a partner there, I guess it's still lead generation. If you're a partner there, your job is largely to bring in business. So I guess it's similar to that. But in addition, you don't have necessarily other partners, which is. Well, you might. I guess, it depends on the size of your firm. So I guess I have to take a step back. Really, there is no difference.
Okay.
If you're a partner at a firm, at a large law firm or at a medium law firm, at a small law firm, you still have the obligation of bringing in clients and then, and doing some of the work. And that's going to be true no matter where you are.
All right.
You have more staff and associate attorneys under you to help out with work in big cases. The larger the firm, of course, the more there is. But then there is also more mouths to feed. So.
Right.
So, yeah.
So in terms of your practice, how do you know when to accept a case or decline a case? What is your process?
Well, there's a few scenarios. It depends on if it's a wage case. It depends on if it's a discrimination case or a sexual harassment case. There are minimum standards that are required by the law in regard to wages. So, if you have a right to be paid at least the minimum wage, you have a right to overtime if you work over a certain number of hours in a day or in a week, assuming you're not exempt for whatever reason, subject to one of the exemptions. But so for those, if they have the ability to estimate, if they're not exempt and they have the ability to estimate what they've been deprived of, whether it be minimum wage or overtime hours or meal or rest breaks, then that's usually sufficient probable cause to bring a case. Okay. So that would be a case that I'd probably be willing to take. Or if they have a contract for a set term and they've been terminated in the middle of that term somewhere, then they usually have the right to the remainder of that contract. So if they have a 2-year contract and that term is set, and then they didn't receive, they were terminated somewhere in there, and they would typically have a right to the money that represents the rest of that contract. Similarly, with commissions, for example, sometimes people are entitled to a commission, and they'll do everything that they needed to do to earn that commission, and then the employer will terminate them before they pay the commission. And they'll say, well, you're not entitled to the commission because you weren't employed at the time we paid the commission. But if they were what we call the procuring cause, so they sold whatever widget, like a car or whatever, they sold it, and they were, nothing else needed to be done. The employer was just going to collect the money from the customer, and now they're pocketing what would have been that person's commission. There's a fairly good argument that that person should be paid the commission because they were the procuring cause. They did everything that they were supposed to do in order to earn that commission. And just because they were terminated before it was paid, that doesn't entitle the employer to the windfall.
Because they performed.
Because the employee performed
right.
the tasks task that was required of them to earn the commission. So that's not always true, but it's often true. I would say it's very often true that they are still entitled to the commission, even though they've been terminated prior to the payment of the commission.
How about the cause of termination? Like, for example, oh, you know what, you killed somebody, or you attacked somebody. That's why we're not paying you the commission. Or you sexual harassed me.
Well, I mean, that could be good grounds for termination. I don't know that that's a good ground for
paying out a commission.
Not paying a commission.
Okay.
If the commission had been earned, but the claim that is usually used to obtain that commission is called breach of the covenant of good faith and fair dealing, which is, I'm getting into kind of heavy law here, but it's an equitable claim. And so other equitable defenses can come into play that would not normally be a legal defense, like clean hands and all these kinds of things.
Right.
So I wonder if an employer might try to argue some of those things. I've never heard of it happening, but
so, like, for example, real estate agents, right? Real estate agents are based on pure commission. If they don't sell a house, they don't get paid. I sell a house, but then I work for a real estate firm and I sexually harass the owner who pays me my commission. And the owner told me, Bobby, you sold this house, but you sexually harassed me. You physically touched me without my permission. Therefore, I'm not going to pay you commission because I'm afraid of my life and you try to touch me.
Wow, you're getting into some really complex facts. So, man, I haven't encountered that situation, but I will say that would be a unique situation because in general, real estate agents are independent contractors, and that's a recognized area of independent contractorship. An employee who earns a commission, the commission are considered wages, and so you generally have no right of offset against wages. But in the independent contractor, it's not. I mean, it's still kind of wages, but it's subject to the contract. So, that could be a unique situation where an employer could try to, offset it.
Okay, now I'll put on a different hat. I am a car salesman. I sold 2 cars, you owe me commission, but I stole the car.
You stole a separate car, I'm assuming.
Right. I stole a separate car. Say from the dealership because I needed to go somewhere. So I didn't tell nobody, but I just took the car and then the owner said, "Hey, I'm missing a car here. Somebody stole it." Oh, and it was Bobby.
So
what's going to happen?
It could only be
What's
Bobby.
funny is you're so just so you know, we have not discussed any of these topics. So what he's doing is he's basically throwing these scenarios at me, and then I'm basically going through a fact, what's called a fact claim identification scenario.
These claims are all fictional. These claims are all fictional for the record.
So off the top of my head, I would say that in general, and a wage employee, you can't offset wages for wage employees. So a car salesperson is probably going to be an employee of the car dealership, not an independent contractor. And so if that's true, then in general, there's no right of offset. But for intentional torts and stealing and such, there is a limited right of offset. So you'd have to there's a better chance that there would be an offset in that case than, in some other instance.
And this is why we have a judge, ladies and gentlemen, correct? That's why we have judges.
Well, no,
yeah,
yeah, that's
right.
True. I mean, in the sense that, so going back to your example of the sexual harassment by the real estate broker against the agent who sold. Yeah, I mean, because someone would have to adjudicate whether there was in fact sexual harassment.
Right.
I mean, and then, they'd have to adjudicate whether there was a valid contract for the commission. And so all these things, to entitle the real estate agent to the commission. So that would be a function of the judge or the jury. And, we don't know everything. That's why, even we have to go back to the books and see
past cases
in particular, but, and then treatises which kind of aggregate these past cases. And the law is evolving. New cases are coming out, and sometimes it represents a drastic change to what we understood to be the law. So when that happens, that's why lawyers have to keep on top of new developments, both statutory, meaning legislation, and also the cases that interpret the laws. So which we do, I think, in general.
That sounds like a lot of work.
Yeah.
Usually we all get caught up in the drama and all the
Well, that's
issues
why
and then
this is the whole point of.
That's a good. I think Joe made it a good point. Often the drama and the emotion pushes you in one direction, but looking at it objectively through the lens of the law,
Yes.
it doesn't change that emotion, but it at least informs you that you may not have a claim.
Right.
So, people will come into my office with, I in particular, I remember there was a guy who was terminated after 27 years for laid off, and they didn't pay him a severance. And he said, "Can they do that?" I said, "Yeah. California's an at-will state.
At will.
They can take any adverse employment action against you for any reason or no reason, but not an illegal reason." But he didn't have any evidence or mind any belief that it was an illegal reason. He believed that it was a layoff, but he was just surprised that after 27 years they would lay someone off without severance, and just saying, bye, no notice, today's your last day.
Yeah.
cold
And-
fire.
Yeah. And so from an emotional perspective, it doesn't seem right, but legally, no remedy. It's totally okay for the employer to do.
Oh, so we could terminate at any time, and we don't have to give them 2 weeks notice. That's if you're quitting.
Right. Well,
Correct?
so I should say advance notice.
okay,
You obviously have to let them
Yeah.
know that you're terminating them,
right.
which is notice, but
Okay.
you don't have to give them advance notice. You can they come in, you can say, today's your last day, or usually they wait to the end of the day, because if they come in, they may be entitled to some period for having come in to the office, they may be entitled to a few hours.
Right.
But, if it's at the end of your shift and you say, okay, thank you, that's it. Now, if you're a salaried employee, you may be entitled to wages through the end of the period, because if you work any part of a salary period, you're generally entitled to salary for the entire period.
Ah.
But still, you can send them home. You can say, this is your last day. You have to figure out with a lawyer or with your HR person how much money they're entitled to, in addition to paying out their PTO or vacation time, which they're also entitled to. But as far as saying, this is your last day, bye, assuming they're not subject to some kind of contract for a set term, yeah, they're generally going to be considered to be at-will employees, and that's it. So, but the employee also has that right to say, today's my last day.
Right.
Thank you, goodbye. I've always thought it was a little bit unfair, because employers will generally just say bye, whereas they expect the employee to give 2 weeks notice or something in order to help the business replace them.
Right.
So it always seemed a little unfair. And they hold some power, because especially if the employee wants a good recommendation. So if they don't give the 2 weeks notice or whatever period of time, they probably can't expect to get a good recommendation. They'll say, that guy left me stranded. He just called in and said he's not coming in. And, so I had nobody to cover that shift, and a terrible employee.
Right.
So if they need that recommendation, it behooves the employee to, try to play nice and give any period of time that's requested by the employee handbook or whatever.
Mm-hmm. And how about when employees quit and they take assets of the company in terms of intellectual property?
Yes, it's theft.
Theft.
I mean, it depends on what you consider to be intellectual property.
Just say a certain. Let's say, for example, ladies and gentlemen, this is hypothetical. Okay, I'm throwing John hypothetical situation. Just say employee knows a certain policy and procedure that is advantageous to the company, and they take this policy and procedure and they implement it at another company.
If it's a complex enough policy or procedure, that can be a trade secret, a misappropriation of a trade secret. But if it's just, we bill people on a 2-week net pay, and they say, and they go to the new company and they're billing in a net 4-week pay, and they say, hey, why don't we do net 2-week? That was what we did at this other place. We'll get paid faster, and that's what everybody's doing. That's probably not going to be considered to be a trade secret.
Okay.
But some things are trade secrets. Often customer lists and vendor lists
Yes.
are often trade secrets.
Perfect.
I mean, if I were to advise an employer, I would say talk to a lawyer about it, because
Right.
first of all, you have to take reasonable steps to protect it.
Right.
Whatever your trade secret is. So the first step is, of course, like a non-disclosure agreement, and then if you want to protect your employees, a non-solicitation agreement. And of course, non-competes are generally unenforceable in California, except under certain circumstances, which
Right.
generally involve the sale of a business. So if you sell your dental practice, you can't then open up, and you have a non-compete, you then can't open up next door and
Right.
try to get all your customers back, right? So generally, non-competes are unenforceable in California, and that's pursuant to statute.
Oh, okay.
There is actually a
So
law
it's
that
statute.
says,
So if I work for a hamburger stand, okay, and
Or
this
help with
hamburger has a special sauce, trade secret, right? And then I want to open up, and I get fired or I quit, and I open up another hamburger stand with a very similar sauce on my hamburger.
But that chef was the inventor of the sauce.
Yeah, or the company.
Yeah,
It better
he
be a-
invented the sauce.
Can I
inside
get
the
sued?
company.
Yeah.
it better be a pretty unique sauce. If it's Thousand Island dressing like most places use,
Right.
there's no way, right? I mean, if Thousand Island dressing, then it's no. But I guess if there was some unique combination,
Okay.
again,
a certain bun, a certain
if
ingredient.
you were gonna,
know.
oh yeah, I would say it'd be pretty difficult, because food components are going to be pretty, unless you're importing some secret ingredient. Even then, it'd be pretty tough. And that's why I think, I don't know if this is still true, but what I heard is that Kentucky Fried Chicken didn't tell their employees what the spices were. Remember the 11 secret urban spice? And they would bring in different batches of the spice that had to be combined different, you know what I mean? Because they didn't want anyone to have any production company to have all the knowledge of what it was. So you do have to take reasonable steps to protect whatever it is you're trying to protect.
Right.
And the most important thing to give you a good argument is to have that non-disclosure agreement, and then to take whatever reasonable steps you would expect. So, but the kind of situation where it comes up most often is in, like I said, those customer and vendor lists. So, especially if you're in sales and you know that this customer buys this number of widgets, they're willing to pay this amount, they need this amount per month, or vendors who transport or whatever. And so you have all these contacts, and then you don't want someone coming in, learning it, and then taking it and replicating it, and then competing with you. So, but that's the most common way we see businesses kind of going after each other. I mean, obviously, if you work for a company, like an engineering company, and you go and you take some specialized design,
specs,
you're working on a patent for them, and you take that technology to another company, and there's a non-disclosure agreement, you're gonna get sued, and as the employee, and the new company is probably also going to get sued for an injunction saying, don't use our technology. That guy took it from us, or guy or person.
Okay, good.
So,
Good. Well, I guess it really depends on the case and the facts that are presented. I mean, every case is different.
It's always very fact specific, yes. And that's why you have to talk to a lawyer about whatever it is. Oh, I think you had asked about this earlier in terms of what is the cornerstone of a case that makes a case one that I would want to take versus one that I would not want to take.
Right.
And that's generally evidence that it's an illegal, what the employer is doing is illegal. Because like I said, an employer can in general terminate or demote or whatever employees for any reason or no reason, but not an illegal reason.
Right.
So if they come to me saying I got terminated or demoted and there's no illegal reason, then I say, well, you sound like an at-will employee who basically the employer can kind of do what they want. Or if they say, I have a gut feeling, I'm an Asian over 40 and I got demoted, and so I think they're discriminating against Asians or people over 40. And I say, well, what evidence do you have? None, just my gut feeling. If it's just a gut feeling, that's probably not a good case. You're the plaintiff. You have the burden of proof to show that it was an illegal reason.
Right.
But sometimes, so I'll try to dig a little bit. I'll say, well, what's that gut feeling based on? Oh, based on some things that the manager said. Oh, well, now we're getting somewhere, because if they said, I don't like Asians because they're too meticulous and they don't know how to socialize, and this guy, there's whoa.
Yeah.
So
interesting.
Or the boss treats Johnny better than me, or something like that. And then I'm Asian, but the other guy is
right.
It's probably not enough just for them to treat one, because they may like that person better for reasons other than ethnicity. It could just be whatever it is. Their kids go to they're on the same little league team or something. But if there's something that they can point to, sometimes it's circumstantial evidence, and I probably shouldn't bring up those terms because it's hard to define, but I mean, it's a definition that I should probably give, but I'm not going to, just because I don't want to make this too legal. But,
sure.
Let's say that a new manager comes in, and you have pretty good reviews for your years at this company, and all of a sudden, all of the people from your ethnicity are terminated. So now that manager didn't say anything about whomever, right? Any ethnicity of people, but it looks odd. It's like you have to then kind of go into the facts again and say, well, do these people have seniority? If they're all the bottom of seniority, they're the least senior people, then it kind of makes sense, or that they have the worst reviews.
Right.
But if they don't, then it becomes a kind of a question, and that's probably sufficient evidence initially to say this may be a case. Why did all of a sudden all of the people of this ethnicity get dismissed? Right. So.
All right. Well, that's very good information, John. I mean, like I said, it's it's like a rabbit hole when it comes to cases.
Exactly.
I mean, it's like you don't know where you're going, because you get emotional, and then you have the science of the law, and then you have past cases, and you have lawyers do that discovery. It's pretty crazy.
Yeah.
No wonder you guys are paid well. That's to solve problems.
I should probably define that term discovery. You used it, and you probably are aware, but it generally refers to the process of obtaining information from the other side, which can be done through written questions or depositions or site inspections, but there are procedures in place to obtain information from the other side. I know that one of the points of this podcast is to try to speak to employees and maybe nurses who may encounter problems at their place of work and what they can do.
Right.
And I, if you don't mind, I wouldn't mind giving a few suggestions in that regard.
Sure, absolutely. Absolutely.
It might speak to your audience a
Okay,
little bit.
all right.
But so basically, if you encounter something, I think like sexual harassment, or you feel like you're the subject of discrimination for whatever purpose, it could be for whatever reason, a protected characteristic. It could be religion, it could be disability, it could be gender, it could be race, age, a panoply of things, and it's generally governed by a law called the Fair Employment and Housing Act, at least in California. You want to document it.
Okay.
So there's a few things about that. You want to speak to HR and put it in writing to HR, but in a polite way. And that's a mistake that a lot of people make, is they go to guns. I mean, figuratively, right? They say, they get kind of aggressive. But the purpose of the initial contact is to try to resolve it. And if you're having problems with a coworker or a manager, you want HR to step in. So you want to document as much as you can, but in particular the circumstances and why you feel it's discrimination, but in a polite way. To say, what, I can't help but feel that this is at the basis, that this is the motive, and and they have a duty in general to investigate it. And so they're supposed to talk to all the parties and any witnesses, and any witnesses that are identified through those witnesses are supposed to be spoken to.
Right.
So that's one thing that you want to do. And often HR and managers don't want to put things in writing. So it's kind of your job to make sure that it ends up that way. So the way that I suggest that happen is, you'll send an email that says, I feel, here's the factual scenario. Here's why I think it's discrimination. Mm-hmm. All I want to do is keep doing a good job for the company and continue my work, but I would like to do so in a discrimination-free environment. They call you up and say, let's talk about this. It could just be that they want a quicker way of communicating, but it could also be they don't want things in writing. Mm-hmm. So then, you follow it up with an email to whomever, the HR, whoever. And, well, thank you for speaking with me today. Uh-huh. So just to clarify, you said this and I said this, and so you said you'd investigate, and I can expect a response within 2 weeks. Is that right? Mm-hmm. Polite. Mm-hmm. But basically, you just converted that verbal conversation, whether it be in person or on the telephone, to some kind of written communication. Mm-hmm. And then you CC yourself and then print it out. Or that's probably the best way, and then print it out and take it. Because if you get terminated, you're going to lose access to your corporate email. You can also BCC it to your personal email, mm-hmm. but they'll know. I mean, if they look through the server, they can see that you BCC'd yourself. Yeah, right. But still, you have that email.
Mm-hmm. Are text messages legal in court in California? Text messages?
Well, they have some problems with authentication because, you don't know it's them.
Right.
So they could say, well, someone picked up my phone or,
right.
So there are some problems with authentication, but in general, if there's been a discourse, mm-hmm. and then you can show that make it more probable than not that it was them mm-hmm. that you were speaking with,
right.
Then yes, I mean, that kind of thing is going to be, it's not a contract, mm-hmm. Because it could be a discussion about what the terms are going to be or whatever.
Right.
But in general, it does show that discussion took place. So if you're asking about with HR, it's very
if we have offer, we have acceptance and consideration, then it's a contract, whether it's written or not, or verbally.
Well, yeah, query as to whether that would be a valid written contract
or verbal contract,
because it's not signed. It's not e-signed or signed, but there obviously is a discussion as the terms.
Uh-huh.
So but it's often very helpful to see what the discussion was between parties, especially when you want to know what the expectations of the parties were. Mm-hmm. So text messages are very important, and mm-hmm.
We'll
often subpoena. We'll ask the other party for them, and if we don't receive what we kind of expect, then we'll ask for the carrier, and we'll subpoena the carrier. And say we want all the text messages to and from this number.
Even a handshake is a form of a contract. If we shake on it, if we physically shake on it and we're like, okay, you're gonna buy my car for $100. Okay, I'll pay you $100 for that car, and you have a shake.
Well, a couple things. Yeah.
Right?
That's it's still a verbal contract.
Prices knuckles these days, though, right?
Whatever.
It's not a written contract still.
Right.
It could be a verbal contract. But also, as you know, some contracts have to be in writing, right? Leases over a year, sale of real estate, guarantees, right? Like if you guarantee someone's debt or something, those have to be in writing. So you can't just handshake it.
Wow.
Or if you tried, they would have a defense. They would say, hey, that wasn't, that's a contract that's required to be in writing. And I don't want to take you through the whole law school.
No, I know.
Because there's exceptions to that.
Right. I just had a case, I'm not going to name names but a case where an HOA promised a contractor a bid on a job. And he said, good job, John. And he shook his hand and goes, we're going to see you later. And then the board of directors didn't agree with that. But the contractor sued the HOA and he won. But he must have had a good lawyer. Because the board shook his hand and said, got the job.
And they probably admitted it.
Yeah.
Because if they had said, no, we didn't,
right.
that might have been more difficult because then it's like he said, she said, and the plaintiff has the burden of proof.
Right.
So what probably happened was that plaintiff said, we had a handshake agreement, it was a verbal contract, and then the board, the president or whoever it was on behalf of the board said, yes, that happened.
Right.
And they said, well, you have actual or apparent authority to do that. Mm-hmm. So that was an agreement, especially if then the contractor or whomever it was took steps to, obtain materials and things like that.
Right.
But, would have really helped that president to say, if he had said, I just have to get board approval. He goes, yes, that sounds like a good price.
Right.
I just need to get board approval. And if the board approves it, then, you can get started.
Right.
Had that been said, that you've heard of condition precedent.
Right. Right.
That would have created a nice condition precedent, and if the contractor agreed that that's what was said,
Right.
I think that probably would have saved the board or the homeowners association.
Tons of information. Here at AMP Spot Talk, again, John Igarashi here. Is there anything else, Joe, that we should talk about?
Again, give us a little bit of information about how anybody can find you in case they need some law consultation or assistance.
Sure. If anyone needed to speak with me, they could call me at 949-667-0150. They can go to my website at igarashilaw.com. I'm also at fairemployment.info. INFO. So those are some good ways. You can Google my name and everything will come up. My state license and everything. So those are all good ways. And if you want to put any of my information into your into the comments or section of your podcast or YouTube video, of course I have to disclaim that nothing I said here is legal advice, and each situation is different, each jurisdiction is different. You should consult with a lawyer in your jurisdiction for specifics as to your individual case, and none of this is a solicitation.
You guys probably have a lot of questions. To ask John. So again, please contact him if you do. You might have a case. You might have a case. You might not, but you might not.
What would be interesting is if people had any questions, probably not specific as to themselves, in which case they should contact an attorney. But if they had any kind of questions, generally about what hypothetical they could put it in the comments section. There you go. Maybe I'll come back and we'll talk about it.
Oh yeah,
there you go.
That'd be a great idea.
You're having a hard day at work.
You're having a hard day at work.
Throw you under the bus.
Right. Why are you having a bad day at work? Is it just because the workload is heavy? Or is it because you're being singled out for some illegal reason? Oh, I should mention one. Complaining about illegal conduct or unsafe workplace conditions does give you some protection. So that'll do that.
Awesome. Well, again, John and Igarashi, thank you so much for being on our podcast today on AMP Spot Talk podcast. Thank you.
Thank you. Excellent. All right, listeners, we'll have more contact here in the next few days. So stay tuned. You never know. You might be on the spot. Take care.
Take care.
Okay,